good afternoon, everyone. Thank you for joining us this afternoon or good morning, depending upon where you're located. My name is Kenya Fairley. I'm a Supervisory Program Specialist here with the Family Violence Prevention and Services Program, and I'd like to introduce my colleagues, Mary Louise Kelly, Director of the FVPSA Program, and Angela Yanelli, a Senior Program Specialist here at the Family Violence Prevention and Services Program. They're both on the line, and you'll be hearing from them very shortly. So before we get started speaking about the final regulation and the new FVPSA rule, as we're calling it in shorthand, we just want to get a sense of everyone that's on the line today. So we're going to take a couple of seconds and do a quick poll. So in a moment, you'll see a polling question appear on the screen, and you'll see a few different categories of how you may identify in your professional work life. So if you can take a moment and click on the label that best identifies how you spend most of your day in your role, that would be really helpful to us. All you need to do is just click on the circle to the left of the label, and you don't need to hit submit or anything like that. But after we have an opportunity to hear back from a few participants on the line, we'll share the results of that poll. As you're doing that, we're also asking for you to take a moment and just introduce yourself in the public chat if you can. Basically just let us know your name, where you're from, such as your state or your tribe or territory. And maybe if you want to just say a little bit about your work, that would be great. So we'll give everyone a few more seconds to respond to the poll. Okay, I think we can share the results. Fantastic. We can see here that the majority of the participants on the webinar right now work in local domestic violence or sexual assault programs, so thank you so much for being here. And then we also have a fair number of people who represent state or territory state coalitions, so thank you for being on the call. If you've selected other, please take a moment and just let us know in the public chat how you identify, and that would be great. So we're going to click back over to the PowerPoint screen. So you should see the title slide in front of you. And I want to tell you a little bit about the FVPSA program, and then we'll get started and just jump right into talking about the legislation. So we're really looking forward to seeing all of your questions and your comments as we move through the presentation. FVPSA charges us to implement welcoming, inclusive, and accessible shelter and supportive services for all survivors of family violence, domestic violence, and dating violence and their dependents. That's the fundamental underpinning of the FVPSA final regulation, is really about accessibility of services. FVPSA was first authorized as part of the Child Abuse Amendments of 1984, and since that time, FVPSA has been amended 8 times. It was most recently reauthorized in December 2010 for 5 years by the CAPS Reauthorization Act of 2010. So FVPSA has a really long history of providing safety and support services to victims of domestic violence and their dependents, and in October of 2014, we celebrated our 30th anniversary. There are several statutory purposes that we have under FVPSA, and you can see those listed here on the screen. Our primary federal funding stream is really for immediate or emergency shelter and supportive services for survivors of family violence, domestic violence, and dating violence and their dependents. We also provide funding for a national network of training and technical assistance resource centers, such as the National Resource Center on Domestic Violence, who's helping us with this webinar today. And then you also may hear from others, and we'll provide resources from some of our other training and technical assistance resource centers to help with implementation of the FVPSA rule. We also provide funding for state domestic violence coalitions as well as territory coalitions, discretionary grant programs, and the National Domestic Violence Hotline, which now includes the National Dating Abuse Helpline, Love is Respect, and Strong Hearts Native Helpline. Each year, FVPSA-funded programs serve approximately 1.3 million victims and their children, and we respond to 2.7 million crisis calls. Those numbers that I just named don't include the number of calls or contacts that are responded to by the National Domestic Violence Hotline or Love is Respect. Annually, the hotline responds to more than 200,000 calls. They conduct approximately 23,500 online chats and receives over 1.5 million visits to their website. Love is Respect, the National Dating Abuse Helpline, responds to almost 16,500 calls. They answer 29,000 digital chats, and they receive more than 2.5 million visits to their website on a yearly basis. So the hotline, Love is Respect, and Strong Hearts, they really do a lot of great work to be responsive to the emergency crisis needs of victims and their dependents as they're calling in, as well as provide other types of information for family members and friends of survivors and others who may have questions. So now I'm going to turn it over to Mary Louise Kelly, Director of the FVPSA program, who's going to talk more about our legislation and the FVPSA rule.
All right. Thank you, Kenya, and thank you to everyone who's joined us today. I appreciate it. I see some names of people who have been doing work in the FVPSA program, the domestic violence movement, for many years, and so some of this may sound very familiar to you. But we thought it was important to provide an overview of the new FVPSA regulation, since this is the first time regulations have been revised since 1996. So FVPSA authorizes the Secretary to prescribe such regulations and guidance that are reasonably necessary to carry out FVPSA provisions. So these regulations incorporate the FVPSA statutory requirements from the 2010 reauthorization, and they also incorporate existing program policies and guidance into the final rule. So some of the guidance that people have seen over the years in our funding opportunity announcements will be incorporated here as well. The rule was published in the Federal Register on November 2nd and became effective on January 3rd, 2017. So since they're effective now, all FVPSA grantees and sub-grantees are expected to comply with the rule. Now, for those of you, like me, who may not read regulations every day of the week, a couple of tips to keep in mind. We're using the term FVPSA regulation and FVPSA rule synonymously, and you'll hear them used throughout the presentation. And the way the rule is organized, you would have noticed when you received the meeting invitation for this webinar that there was a copy of the regulation attached. And just to give you an idea of how you might want to read it, the organization is set up so there's at the front there's a large section called the preamble. And that preamble summarizes the notice of proposed rulemaking that was sent out earlier in 2016, some of the comments that we received back, answers to questions that were posed in the notice of proposed rulemaking. This information provides some good background and examples to inform the regulation text itself. The last 10 pages or so of the regulation are the actual regulatory language. And so if you wanted to just focus your reading on the actual regulation, you should look to the last 10 pages of the reg. So to give you a helicopter view of what you're going to be seeing, we will walk through each of the sections in the regulation and give you some updates on some of the new and changed guidance. So beginning with the definitions section. The definitions of domestic violence and dating violence have been updated in the regulation. Historically, the terms domestic violence and family violence have both been used in FVPSA because in 1984, when FVPSA was first passed, family violence was the term of art for what we might now call domestic violence or intimate partner violence. So the domestic violence definitions that you see now have been updated. They're consistent with the Violence Against Women Act of 2013, and dating violence definitions also incorporate some language that is consistent with the Centers for Disease Control definitions of dating violence. On the next page, other definitions that have been added are definitions for primary prevention and secondary prevention. While prevention is a really important part of FVPSA, we've never really defined what was intended by prevention. So these definitions were added, and again, these are consistent with the Centers for Disease Control and World Health Organization definitions of primary and secondary prevention. Other definitions. Personally identifying information is a term that is used in FVPSA but had not previously been defined. So it is included here to make it clear that personally identifying information goes beyond first and last name, social security number, and address to include any information that alone or in combination might serve to identify an individual. Another definition that is used in FVPSA to define the membership for representatives in the state domestic violence coalitions is the primary purpose domestic violence service provider, and coalition membership needs to include the majority of those providers in their state. So FVPSA added a definition so that it would be clear that this referred to nonprofit, non-governmental organizations, tribes or tribal organizations that have as their primary purpose operation of shelter and supportive services or non-residential counseling, advocacy, and self-help services for victims of domestic violence. We also updated the definition of shelter. This definition of shelter expands traditional emergency and congregate shelter to include more flexible housing options and supports that don't necessarily require families to live in a congregate shelter. It increases flexibility for programs to use other sheltering options, which may be hotel or motel vouchers, or lodging in properties that may or may not be owned by the program. However, it also clarifies that just making a referral to a shelter or a temporary housing is not considered provision of shelter under FVPSA. FVPSA requires the shelter be supplemented and include supportive services such as advocacy, crisis intervention, and counseling. All right, so moving on, one more definition, the definition of underserved populations. The regulation clarifies that this means populations who face barriers in accessing and using victim services, and then provides examples of those populations, which are very broadly defined to include geographic location, religion, sexual orientation, underserved racial and ethnic populations, people with disabilities, age, those affected by substance use disorders and mental health issues, among others. In addition to these underserved populations, the Secretary can include other populations that he designates as underserved, and those designations would be included in future funding opportunity announcements. The next section of the regulation provides a list of the government-wide and HHS-wide regulations and statutes that apply to FVPSA programs. So Section 1370.3 includes a list of the non-discrimination regulations that apply to FVPSA programs. And examples include prohibitions against discrimination based on sex, religion, race, color, national origin, disability, and age. And other regulations that apply to FVPSA as well as other HHS programs include things like statutes on protection of human subjects for research and the requirement for drug-free workplaces. The next section, 1370.4, addresses the confidentiality requirements in FVPSA. And as many people know, FVPSA has very strong requirements to protect the privacy of victims of domestic violence, given the safety risks involved when people are fleeing domestic violence. And since this is an area requiring significant training and technical assistance and guidance, the regulation provides some clear guidance on some of the key facts. As I mentioned, it provides clarification on the definition of personally identifying information, and then it makes clear that FVPSA grantees shall protect the confidentiality and privacy of survivors and may not disclose any personally identifying information collected in connection with services without informed, written, and reasonably time-limited consent. And there is additional information on what reasonably time-limited consent would consist of. Informed consent cannot be a condition of eligibility for services, so survivors must choose to consent to sharing of their personally identifying information and cannot feel compelled to do so in order to access services. In addition, the reg addresses informed consent in the case of a minor survivor which must be obtained from the parent or guardian unless the parent or guardian is the abuser or suspected abuser. So what happens when the release of information is compelled by statutory or court mandate? Well, the regs state that grantees should make reasonable attempts to provide notice to survivors affected by the release of information and take steps necessary to protect the privacy and safety of the persons affected. So that commitment to safety and privacy really isn't alleviated, and advocates should make every effort to protect the survivor and their information. The regulation also clarifies that there are times when grantees may share information, and that's grantees may share non-personally identifying information in the aggregate in order to comply with reporting requirements. They may also share court-generated or law enforcement-generated information for protective order enforcement purposes. And personally identifying information can be shared with healthcare providers if providers are given informed written consent that is reasonably time-limited. All right, Section 1370.5 describes some additional non-discrimination requirements. So in addition to the government-wide regulations, anti-discrimination regulations, the regulation also includes requirements against discrimination on the basis of religion. And it provides examples of when religious accommodation may be necessary. For example, a victim of domestic violence may need to have food preparation requirements that differ from others, food that they may or may not eat because of their religion. They may need accommodations in terms of chores so that they don't have to do chores on a Sabbath or a holy day. The regulation also includes requirements against discrimination on the basis of actual or perceived sex, including gender identity, and this includes both the survivors and their minor children, who must have equal access to shelter and supportive services, regardless of sex, including gender identity, or regardless of sexual orientation. Now, for a little more information on these additional non-discrimination requirements. The regulation addresses the fact that there may be times when sex segregation or sex-specific programming is essential to the normal or safe operation, and that when this happens, grantees must provide comparable services for individuals who cannot be provided with programming otherwise. So, for example, if facilities, despite their best efforts, cannot accommodate services for men and women in the same facility due to shared bathrooms or sleeping arrangements, it is imperative that both men and women are offered comparable services that would include a comparable length of stay, that everyone would receive the same access to supportive services such as support groups or counseling, and that if someone is placed in a separate location, they would receive transportation to access those services. In addition, transgender and gender nonconforming survivors and their minor children must have equal access to FVPSA-funded shelter and non-residential programs, and access to those programs and to placement in those programs must be based on the individual's self-identified gender identity. Um, 1370.5 continues with additional non-discrimination requirements. Services must be provided without requiring documentation of immigration status. The Department of Health and Human Services has determined that FVPSA-funded services do not fall within the definition of federal public benefits that would require verification of immigration status because they're life-saving services, and everyone who needs them should have access to those services. In addition, the regulations specify that grantees and sub-grantees should create a plan to ensure that effective communication and equal access are available to individuals with limited English proficiency, that qualified interpreters and translation services are offered, that taglines are used, and I don't know if anybody else if everybody else is familiar with the term, but for me, I looked into that term, taglines. It's basically language that is used to inform individuals with limited English proficiency of the availability of language assistance services. It's also critical to include in that plan procedures and approaches for communicating with individuals with disabilities. And these non-discrimination requirements are enforced on the non-discrimination requirements on the basis of religion, sex, gender, including gender identity, are enforced through Section 602 of the Civil Rights Act of 1964, so through the Office of Civil Rights. But the non-discrimination requirements on the basis of sexual orientation are enforced programmatically, so that'll be some of the work that is done through monitoring at the state level and through guidance offered through the FVPSA office and through the department. In some of these areas where this requires training for local programs, some challenges programs may have in complying with all aspects of the regulation, please know that we are working with the FVPSA resource centers on domestic violence to develop tools that will help programs do an assessment of whether they are able to comply with all of these the requirements in the regulation, to identify training and technical assistance to help programs in offering inclusive services for all victims of domestic violence, and products that will specifically address some of the places where we have challenges. We will be having time at the end of the webinar for some questions and answers, but I'd really like to invite all of you to use the chat box to submit any questions that you have so that we can, for those we cannot address today, we can use them to develop the training and technical assistance tools and frequently asked questions that we plan to share broadly with all FVPSA grantees. So I encourage you to jot down your questions in the chat box, to raise them at the end of the webinar, and to know that we are in the process of developing additional guidance, training, and technical assistance to address some of the questions that may come up. At this point, I'm going to turn the webinar over to Angela Yanelli, who's going to provide an overview of how the regulations address the requirements for states, tribes, and coalition grants. Angela?
Thanks, Mary Louise. Good afternoon or good morning, as Kenya said, depending on where you are. I'm Angela Yanelli, and I'm pleased to bring to you a little bit of information about the FVPSA regulation for states and Indian tribes formula grants. It's Section 1370.10. As you all may know, 70% of the FVPSA appropriation goes to states each year for making sub-awards to eligible domestic violence programs, and another 10% goes to fund federally recognized tribes and tribal organizations. I want to take a minute to say for note that FVPSA defines the term state to include the 4 U.S. territories of Guam, American Samoa, the Commonwealth of the Northern Mariana Islands, and the U.S. Virgin Islands. And this is also true whenever you hear the term state domestic violence coalitions. So we're talking about the states and the territories. So we're going to cover a few of the more important points in the rule with respect to grants to states and tribes. But most of these are not new, but rather just a restatement of the language or the intent of the statute to better align with best practices and policy guidance. Some of the points will apply universally to both states and tribes, and others, such as the application criteria, will vary depending on whether it is a grant to the state or a grant to the tribe. So as Kenya said at the beginning of the presentation, it is important to understand that the overall theme of the new rule is inclusivity, accessibility, capacity building, collaboration, and partnering. In particular, FVPSA wants to see states, tribes, and domestic violence coalitions working together to identify the needs of all stakeholders, including bringing the voices of unserved, underserved, and inadequately served populations to the planning table, as well as conducting outreach efforts to build the capacity of these organizations that serve these populations. States are required to consult with and provide for the participation of state and tribal coalitions in the state planning process for the distribution and administration of subawards to eligible programs. And this is one of the new things in the rule is the inclusion of tribal coalitions in this process. In addition, states must involve culturally specific and underserved communities in state planning, and tribes should be included where appropriate. States submit an application, sometimes we refer to that as the state plan, that identifies the populations in the state that are underserved, a description of those that are being targeted for outreach and services, and a brief explanation of why those populations were selected, including how often the state revisits the identification and selection of those populations to be served with FVPSA funding. The outreach plan should include training and technical assistance that the state will provide and the leadership role played by those representing and serving underserved populations. States should review their demographics at least every 3 years or explain why this process is unnecessary. All states and tribes include an assurance in their application that supportive services provided by FVPSA grantees are voluntary. In addition, the receipt of emergency shelter cannot be conditioned on participating in supportive services such as counseling, parenting classes, or mental health or substance abuse treatment. States and tribes assure that FVPSA grantees do not use inappropriate screening mechanisms for admission to shelter, such as criminal background checks, sobriety requirements, requirements for legal remedies like a civil protection order, or mental health or substance abuse disorder screenings. And this last bullet point is really important. Services are voluntary, and there's no condition for the receipt of emergency shelter. Okay, we're going to the next slide. The state application includes documentation of how the state will plan and consult with state and tribal coalitions, including the participation of underserved communities at the state's planning table. States and tribes describe how they plan to use the grant funds, including the expected results. It is critically important that states work with coalitions and tribes to solicit their feedback on program effectiveness, which may include recommendations such as establishing program standards and participating in program monitoring. State and tribal grantees also assure that they have a law or procedure to bar an abuser from a shared household or a household of the abused person, which may include eviction laws or procedures where appropriate. And finally, states describe procedures to assure an equitable distribution of grants and grant funds within the state and between urban and rural areas. The rule allows states to use the U.S. Census definitions, or they can use their own state definition of urban and rural as long as it is supported by data and has public input prior to its adoption. So this is another new thing with the rule. All right, now we're on to Section 1370.2 on state domestic violence coalitions. State DV coalitions receive 10% of the annual appropriation just like the tribes do. Again, these are the state and territorial domestic violence coalitions. And coalitions reflect a federal commitment to reducing domestic violence by urging states, localities, cities, and the private sector to improve the response to domestic violence, encouraging stakeholders and service providers to move towards an integrated service delivery approach that meets the needs of all victims, including those in underserved communities. to provide for statewide training and technical assistance, to increase public awareness about and prevention of domestic violence, and to increase the quality and availability of shelter and supportive services. So clearly, coalitions have a big role to play in the FVPSA world. As was mentioned earlier, the definition of primary purpose domestic violence service provider has been incorporated into the rule to clarify the membership requirement for a state domestic violence coalition. It is not intended to describe the eligible entities for the receipt of subgrants awarded by states. And as Mary Louise mentioned, coalitions must include a majority of the primary purpose DV service providers in the state in their membership. Board membership for coalitions should be representative of the primary purpose domestic violence service providers and may include representatives of communities in which the services are provided. Also, the financial sustainability of coalitions as independent, autonomous 501c3 organizations should be supported by both its membership and its board. And HHS has the exclusive discretion to designate coalitions for FVPSA funding purposes. Another responsibility of coalitions is to conduct needs assessments. Coalitions and states should work together in partnership to utilize the information from these needs assessments that are conducted by the coalition as well as those that may be conducted by the state into the state planning process. Needs assessments should involve representatives from underserved and culturally and linguistically specific populations. All right, next slide, we are on to the National Resource Centers. FVPSA provides for no less than 6% of the annual appropriation to be used for National Resource Centers and training and technical assistance centers. There are four.
Interrupt you just for a second. Some participants aren't seeing the slides, so I'm going to quick close them out. I didn't want to scare you when they disappeared.
No, it's fine.
And relaunch them for everyone, and hopefully that'll reset it for participants so that everyone can follow along. All right, go ahead.
Okay. Okay, so there are two National Resource Centers, the National Resource Center on Domestic Violence and the National Indian Resource Center addressing domestic violence and safety for Indian women. There are four special issue resource centers. Each one of these must focus on at least one of the following: criminal and civil justice systems, child protective services and child custody, health care and domestic violence, and mental health system responses to domestic violence victims and their children. There are three culturally specific special issue resource centers that enhance domestic violence intervention and prevention for victims of domestic violence who are members of racial and ethnic minority groups. And new to the 2010 reauthorization of FVPSA is the addition of state resource centers to reduce disparities in domestic violence with high proportions of Native American populations, including Alaska Native and Native Hawaiian. And we are very happy to say that for the first time ever, FVPSA has just released the funding opportunity announcement for the Alaska Native Tribal Resource Center on Domestic Violence. The due date is September the 8th, and eligible entities must be located in a state in which the population of Indians, including Alaska Native, exceeds 10% of the total state population, or be an Indian tribe or tribal organization that focuses primarily on issues of domestic violence among Alaska Natives or an institute of higher education. Applicants must demonstrate the ability to serve all regions of Alaska, including the underdeveloped areas and areas that are geographically distant from population centers. So we're very excited to see what comes from that program and that it continues to get funding into future years. Also new with the 2010 FVPSA reauthorization is the grants for specialized services for abused parents and their children. When the FVPSA appropriation exceeds $130 million, 25% of the amount over the $130 million is set aside specifically for this program. The grants in this program serve to expand the capacity of programs to prevent domestic violence by addressing the needs of children exposed to family violence, domestic violence, and dating violence. The first time this program was put into the budget was in fiscal year 2016, and they are 2-year grants. The National Domestic Violence Hotline also receives a separate allocation of funding to provide a 24-hour national toll-free hotline to assist adult and youth victims of domestic and dating violence, as well as family and friends, service providers, and other concerned persons. The rule helps clarify what the term telephone means. Our statute's a little bit behind, and we have to understand that telephone really now includes digital technology such as texting, online chatting, video communications, voice recognition, internet, cable, and other emerging technologies. So the rule does provide for that new clarification. And I believe that is the end of my part.
All right. Thank you so much, Angela. I think Mary Louise is going to make a couple of additional remarks before we take a look at some of the questions that we may be able to answer now.
All right. Thank you. And thanks, Angela, for covering that great information and giving me a moment to find my unmute button. So yes, we are all working together to implement this regulation, but know that it means that all of us will be working together at the local, state, and national level. I think that now you've heard the updates on some of the new and revised information, and much of it will probably sound very familiar to those of you who've been working on the FVPSA program for some time. But there are a few areas where people have ongoing challenges, sometimes complying with the requirements. And those are the areas where we will be particularly working with the National Network of Resource Centers, FVPSA Resource Centers on Domestic Violence, to help provide support and training and technical assistance on issues such as how do we provide voluntary services, and what if that's difficult and it requires changing our rules in our program? How do we develop a language access plan? We need training on confidentiality for people in our community so they understand our requirements on not being able to share personally identifying information. Those kinds of questions come up over and over again in programs across the country. So just know that we're working with the Resource Center Network to develop a tool that will help local programs do a self-assessment, not an assessment for us, but an assessment to say, do we have these procedures in place and training in place? We're also asking them to identify existing training and technical assistance tools and resources that will support you in your efforts to implement the programs in compliance with this regulation. And we plan to conduct a series of webinars and product releases that will address some of these specific areas of concern or specific grantees, such as a webinar that will be held for FVPSA tribal grantees in the coming weeks. So we're going to open it up for a question and answer session shortly, but as you can see, you have contact information for Kenya Fairley, who's the Supervisory Program Specialist here at the FVPSA program, for some follow-up questions. But for those of you, and I think most of the people on the phone, are FVPSA grantees with formula grants for states, coalitions, or tribal grants. And if you are, then you're probably familiar with the FVPSA program specialist who works with your regions. And they'd be your first line of contact for if you have questions or concerns you'd like to raise. Know that we're working together across all of the FVPSA teams to collect the questions that come up and to develop a frequently asked question document that will give you the official answer and guidance on implementing the regulation, and that will also communicate some of these needs and questions to the training and technical assistance providers. So I'm now going to turn to Kenya and ask, Kenya's been tracking the chat box and is going to mention some of the questions that have come up, some of the trends. Kenya?
Hi, thanks, Mary Louise. So one of the questions that's coming up, I'm just going to kind of generalize a couple of the questions into one because we do want to go back and take a look as we're working on the FAQs that Mary Louise just referenced. We want to make sure that we're providing very clear and consistent guidance. But a couple of questions that have come up relate to the definitions of family violence and domestic violence or intimate partner violence, where it may seem what are the types of services and supports that can be made available to victims of family violence, where it may be sibling on sibling or some other relative, and not necessarily intimate partner violence between two intimate partners. So the questions are around, can those services still be provided with FVPSA funds, or if you can just speak to the use of those definitions interchangeably a little bit.
Sure. This is Mary Louise, and I'll take that on. The regulation, and particularly going back to the notice of proposed rulemaking and the answers to some of the comments and questions that came in, provide some of the history around FVPSA legislation, the intent of the funding, and the history of these definitions over time. And basically, the emphasis is that these funds are intended to address the problem of domestic violence or intimate partner violence. The legislative history and the history of this program and legislation are very clear on that. However, we understand that people who come to domestic violence programs often come with a lifetime history of trauma, many things going on in families except other than domestic violence or intimate partner violence, and there may be a range of issues that families need to address when they're working with a program. So while these funds and the purpose of the FVPSA program is to address intimate partner violence and domestic violence, and programs should be designed to do that, we understand that some of the advocacy services will involve helping families through some of the other challenges they face in life, which may include other violence that they're experiencing in the family or the community.
Okay, thank you. Another question that's come up in a couple of different ways talks about how the new FVPSA rule interacts with the VAWA provisions, particularly around non-discrimination. So if you can talk a little bit about how the two sets of legislation and regulations relate to each other.
Okay, I will do my best. I also noted a question in the chat box around whether we've reached out to colleagues in HUD and elsewhere, and I want you to know that there was a great deal of consultation between the Department of Health and Human Services, Department of Justice, and Department of Housing and Urban Development in the development of these regulations, because we understand that FVPSA grants and VAWA grants and HUD grants oftentimes end up funding the same programs. So particularly in the area of non-discrimination provisions, we tried to be very careful to have somewhat consistent guidance, and it came up often in the area of anti-discrimination provisions concerning sexual orientation and gender identity. So to a great extent, our guidance is very similar to both the HUD guidance and the Department of Justice guidance for Office on Violence Against Women grants. VAWA does include a provision around sexual orientation discrimination that I think is addressed somewhat differently from the HHS provision. And in HHS, anti-discrimination on the basis of sexual orientation is enforced through programmatic oversight mechanisms, and that may differ slightly from how VAWA addresses discrimination on the basis of sexual orientation. But we did make every effort to try and make definitions, procedures, and guidance be somewhat similar. And also recognize that, in many cases, the FVPSA program, we understand that this is one grant program among many that programs may apply to or may receive funds from, and that FVPSA is not the only guiding regulation. And particularly because most of FVPSA funding is provided through formula grants, we may not specify every detail or provide very specific guidance on how programs need to be run. We understand that we're not the only funder of domestic violence programs and that there are many funding authorities that may provide direction. So understand that we may not provide very detailed guidance and that a lot of the flexibility for guidance and administration of FVPSA funds may fall to the states, the territories, and the tribes who are administering these funds. Are there other questions?
Your response to this last question, I think, leads right into another question that came up, which was speaking about how we define underserved communities and how they're identified. For example, would we consider sex, gender, or gender identity to be characteristics under which to define an underserved community?
Yes. I'll go back to that. Let me see. I'm looking at the slide that covered the definition of underserved communities. And that is, but it definitely does include in underserved populations those who are underserved because of sexual orientation or gender identity, and many, many other categories. I'll look back to the slide so I can refer you to it. But it's on slide 10, and perhaps we can go back to that. It lists out the underserved populations. There we go. So as you can see, it's a broad range of populations can be included as underserved populations. They're those who face barriers in accessing and using victim services. This is the underserved populations definition includes these populations, and as I mentioned, it also includes other populations that the Secretary may designate as underserved, which and those populations might then become priority populations for service under FVPSA. I hope that answers your question.
Excellent. I see a note here that we do not have sex and gender listed on slide 10, so we will take a look back at that. I do see that we have gender identity listed here.
And sexual orientation, yeah.
And sexual orientation. So we'll go back and make sure that we clarify that so that everyone has a clear understanding. So thank you for that. So Angela, this may be a question that you can help answer, and this speaks to, can you talk a little bit more about the questions that would be prohibited when determining eligibility for shelter? I believe you may have been speaking about that, but if not, Mary Louise, please jump in.
Well, sure. Obviously, I'm going to go back to the slide. It was
that was slide 7.
It's hard. 17.
Yep.
Yes. So what we're talking about is for the receipt of emergency shelter to be able to get into the door. There's to be no condition. We want to be inclusive. We don't want to screen out. We want to screen in. So if you're asking questions such as, do you have documentation of your immigration status? Do you have a protective order? Do you have any kind of intrusive question that could be a barrier to keeping someone from getting the safety that they need in shelter would be something that FVPSA would not support. Now, once someone is in shelter, it's a little bit different because you've had a time to assess and see where they are, monitor behavior, see what's going on, and if there are some behaviors that are against the policies and procedures of that program, then the program has the opportunity to explore that and see how they can try to make arrangements to get that person where they need to be, either to make arrangements in that shelter or to find alternate place. But the key is to be inclusive, screen in.
And I just want to add, this is Mary Louise, from the list of conditions for admission to shelter. Inappropriate screening mechanisms also include criminal background checks, sobriety requirements, mental health or substance use disorder screenings. So I think those were some of the other inappropriate screening mechanisms that you might have mentioned, Angela, that person may be asking about.
Right.
Excellent. Thank you so much for that, Angela. Another question for you that I think you may be able to speak to. My computer is freezing a little bit. The question is about the needs assessment. Can you talk a little bit more? I believe you shared a bit of information about the needs assessment, but if you can talk a little bit more about the kind of information that would be required. This person has seen some other states that have very comprehensive needs assessments, so they're just wondering a little bit about that. I know we're going to provide greater guidance and instructions on that in the future, but if you can share any more with the audience, that would be great.
Sure. FVPSA does not define what a needs assessment needs to look like. It's left up to the coalitions to do that, as well as the states. Many states are doing their own needs assessments, but coalitions are really charged with doing that in the statute. The goal of that is to be inclusive. You're going to hear those words over and over. Be inclusive, include representatives of underserved populations, and to look for what the barriers are in the state. Identify who's not getting served or who's not getting served well. And the needs assessments have to go beyond just your member programs, because coalitions could be comprised of just a few member programs, and there may be many more in the state. So you do have to go out beyond your own borders if you're a coalition. Statewide needs assessment, be inclusive, work with the state. They're often doing their own needs assessment so that there's not a duplication of efforts. But it really is sort of left up to the coalition on what those will look like. I imagine as we've been doing a lot of work in our regional groups. I know that the few regional meetings that we've had so far, there's been a big interest in exploring what a template would be for a monitoring tool. I imagine that the same type of process will continue and explore over to needs assessments as well.
Excellent. Thank you, Angela. So our very last question of this session that we're going to address, and please know that we do intend on answering each of the questions that have been posed here. Some of them just require us to go back and do a little bit more digging to make sure that we're giving you a very clear and comprehensive answer. So once we're able to send out the PowerPoint slides, we will include some additional resources to help you all with the implementation of the rule. We will include a frequently asked questions, which we will update on a continuous basis, but we will include that to help clarify some of what we've talked about and some of what's in the rule. And then we also plan to continue doing these types of webinar sessions over the next several months. So this is just the beginning introduction, and then we're going to have more webinars where we can delve into some of the issues a little bit more deeply around comparable services, definitions of shelter, all of the different types of things that we talked about here. So please be on the lookout for those. So our last question speaks to, can you talk a little bit about FVPSA's intentions or hopes for sustaining and continuing to support culturally specific trauma-informed programs across the country? So Mary Louise, I'm passing it over to you, and then you can take us on out.
All right. Well, that's a big question. I think that when you look at the purpose and goals of the FVPSA program, always one of the first and foremost has been our intention to ensure that domestic violence programs are available and accessible to all populations, including culturally specific populations. As many of you know, we have invested and focused on the development of culturally specific programming through the FVPSA program for many, many years, beginning in 1999 with the development and initial funding for the Culturally Specific Institutes on Domestic Violence. And that continued focus on this work has continued as we most recently funded a discretionary grant program for culturally specific trauma-informed services, recognizing that this is an area of work where additional research is needed and additional funding to lift up the impressive culturally based and culturally informed work that is happening in so many communities. So know that that continues to be a priority for FVPSA, and in every way that we have the capacity to do that work, we will continue to do it, whether it's through Resource Center training and technical assistance grants, through the very limited discretionary grant funding that we're able to provide. We will continue to make a real priority in this work, making sure that domestic violence programs across the country have the capacity to be fully accessible and available for the most underserved and marginalized communities in this country. So that's a commitment, I think, that has been a hallmark of the FVPSA program's work and will continue to be. So we need to wrap up, and I want to thank everyone who stayed on the phone and stayed on this webinar for this overview of a regulation. Not always the most titillating presentation when you have to go over the requirements of a regulation, but important. And I want to encourage anybody who hasn't had the opportunity to do so to really read through the regulation. As I mentioned, the last 10 pages or so of the regulation that is attached to your announcement really gives you the language of the FVPSA regulation. And I think it's important to read in addition to just the overview that we're able to provide on the PowerPoint slides. So thank you for taking the time to do this. And again, thank you for the work that you do every day to help victims and survivors of domestic violence and their children. Good afternoon.